Hello and welcome back to the another episode of Daily News Analysis for IAS 2025. It is 10th August today and we are going to discuss the six important articles which were in the newspaper today. Every day we upload this video on the YouTube on this YouTube channel. Actually, we upload two videos every day on this YouTube channel. In the first one, which is this video, which is in the morning session, we discuss the daily news analysis. We discuss the most important articles which are relevant for your preparation, and we try to break them into the simplest language possible. We try to break these articles into the simplest language so that it would be easy for you to understand it and take the most important information from these articles and pile up your preparation. And also in the evening session, we upload another video in which we discuss the daily quiz. We discuss the questions related to the current affairs itself so that it will give you a brief idea how the questions could be framed from the current affairs in the exam, and also it will help you revise your current affairs. And also in that session we discuss few questions from the previous year question book also, so that it will give you the absolute idea how the questions do come in the exam and what are the methods by which you can solve those questions and how we can implement that knowledge in the upcoming next exam. So this was about this initiative. And also guys, I would like to first before we start our discussion, I would like to request you, please do subscribe this channel and share it with your friends so that they may also get the help which they need. And also when you subscribe, it gives us the motivation to work more hard on it and give the best information possible. So without any delay, let's look at the topics which we have to discuss today. There were various first I would like to say there were various articles in the Hindu newspaper today itself. Some of them we had discussed various times in our news analysis, and I thought it is not recommended that to discuss any article on the daily basis. To me it is the waste of time. We are wasting our time if we will discuss one article for many days. So the purpose of this is to, what we do, we take up those articles which we had least discussed or which we had not discussed at all. So to first to improve the information base, second to reduce the time which you spent in reading these newspapers. So this is about this initiative. Now let's without wasting any time, let's have a look at the articles here. The first article, we have to discuss it with respect to the Supreme Court gave bail to the Manish Sisodia in Delhi excise policy. You know, the topic itself is not relevant for your exam. They are not going to ask you when did Sisodia was granted bail by the Supreme Court. They will not ask you with respect to him. But there were few statements made by the courts in this granting of this bail which are very much important for us to understand, and it shows us towards what direction our courts are turning to. And we had already seen few days before when the courts took up the section 45 of the PMLA, on which they are going to review, which is based on the granting bail who are under the money laundering accusation. So this will definitely, it shows the direction of the Supreme Court towards this. The second article, it is about the elections to be held in Jammu and Kashmir. Chief Justice of sorry, Chief Election Commissioner, he stated that very soon the elections in the Jammu and Kashmir will be held, and the democratic democratically elected government will be there in Jammu and Kashmir. Since 2014 there has been no election in Jammu and Kashmir, and since 2018 Jammu and Kashmir is under the central rule. So because of the protests from the parties we had discussed yesterday also, the Supreme Court, Chief Election Commission came to this solution, and very soon they will release the dates, I guess. After that, we will discuss about the recently the Supreme Court judgment with respect to the subcategorization of caste, that states can go for that. And in that they mentioned about the states should also look at the creamy layer in the as SCs and STs. But that was not the order from the Supreme Court. It was just a suggestion, and with respect to that, the government says creamy does not is not applicable to the scheduled castes and scheduled tribes. So we will discuss about it. After this, we will take up the another article. It is very much relevant for in the science and tech related article. India to roll out new treatment regime for drug resistant tuberculosis, which is an issue right now. After that, we will discuss an article in the editorial section about the no population census. How does it impact our policy making and why it is important? Is it delayed or is it you know is it a conscious delay, or there were things, uneven things by which the government could not hold the population census. After that, we will finally go to a bill proposing four nominees in a bank account tablet in Lok Sabha. It is about the banking amendment bill, so we will discuss about it also. Now let's go to the first topic, in which the Supreme Court they granted bail to Sisodia. Supreme Court on Friday stressed to the Central Bureau of Investigation, which is CBI, and the ED, which is Directorate of Enforcement, that every day counts in matters of personal liberty. Whenever they, one thing we have to understand: if anybody is held under the PMLA Act, anybody is held under the Money Laundering Act, for them to grant them bail is not that easy for the courts, because the provision of showing that the accused is not guilty, it is accused has to show that he is not the guilty, not the authority who arrests them. So it gets very difficult for them to get the bail. But here the condition, the Supreme Court is showing its trend is changing right now, and it has showed that since it has been 17 months that he was in the jail without any trial. Now we cannot punish him because we are not able to give him this speedy trial. We are not able to give him the we are not able to judge his case that quickly. So we cannot punish him because of that and give him the imprisonment. We cannot punish him by not giving him the bail. So with respect to that, the Supreme Court stressed to the Central Bureau of Investigation and the Directorate of Enforcement that every day counts in the matters of personal liberty. And also about the Manish Sisodia, he spent 17 months behind the bars without trial for money laundering linked to Delhi excise policy. You know, Further, the Supreme Court said that the right to a speedy trial and personal liberty were very important, and bail cannot be withheld as a punishment. We have to go for the speedy trial, and if we are not able to go for the speedy trial, then we have to give them the bail. We cannot withhold this bail. We cannot withhold this right of the person. And also further, the Supreme Court said that if the state prosecution agencies or even courts do not have the wherewithal, you know, protect an accused's right to a speedy trial, they should not withhold bail on the grounds that the alleged crime was serious. What does it mean here? That if the courts are not able to go for the speedy trial, or these authorities are not in a position to go for the speedy trial, then courts cannot withhold this bail for the accused, because that they believe, because the allegation is that the crime they had done is very severe. So this cannot be the reason for withholding the bail. So here we can see the direction of the mentality of the courts changing right now. As we saw in the section 45 of the PMLA, we saw that there were two important points with the twin test which the courts have to check. One was accused is not guilty. That is, to the court, they feel that accused is not guilty. And the second test was the accused is not likely to commit any offense on the bail. So here in this case, the court said, the judges said that here, if the authorities are not able to go for the speedy trial of this particular person, then we cannot withhold his bail, because we believe that the crime he has done is very severe. That cannot be the reason. So it indirectly shows the trend. The Supreme Court is going to review this section 45 of the PMLA, and I personally believe that now maybe the Supreme Court may change this, and Supreme Court may call it unconstitutional, I believe so. So let's see, still we have this act, and here we have this judgment, we have this judgment with respect to the bail of Mr. Sisodia. And in it, the Supreme Court said, for that particular reason, if authorities or the court is not able to go for the speedy trial, we cannot punish that person in particular, that we can hold his bail. So we have, irrespective of the crime he has committed, he has been allegedly committed. And also for this, the Sodia, he has to pay 10 lakh in bail bonds. And also, these authorities, they made an oral pledge to the Supreme Court that he should be barred from entering the secretariat, but the Supreme Court declined this oral plea made by the ED and CBI to bar Mr. Sisodia from the Delhi secretariat. The court said Mr. Sisodia had deep roots in the society, and there was no possibility of him trying to flee or tamper with evidence or influence witness. So Supreme Court denied this oral plea from the ED and the CBI, that he should not be, he should be barred to enter the secretariat. Now he can go into the secretariat. And also Supreme Court further added that not giving bail is the violation of Article 21. So this was about these important points which the Supreme Court made, and it shows the direction which we are moving towards now with respect to the people who got arrested under the PMLA Act, and how the Supreme Court is changing its direction. So this was the importance of this article. I hope you understood it. Now let's move towards the another article of today's discussion, which is elections to be held in Jammu and Kashmir. If you had read the yesterday's newspaper, we had seen how many regional and national parties in Jammu and Kashmir, they were protesting against and were demanding that the elections should be held in Jammu and Kashmir very soon. And with respect to that, we should know few points about the Jammu and Kashmir, which had happened recently. By recently, I mean from last 1 decade. The last election and the last state legislative election was held in 2014, and in 2018 we saw that how abrogation of Article 370 happened, and the statehood of the Jammu and Kashmir was diluted. And we saw the Reorganization Act of Jammu and Kashmir. We saw that how different UTs were formed from the state of Jammu and Kashmir. And still from the 2018 till now, Jammu and Kashmir is in direct rule of the center. So because why did the government did not went for the elections? Because of the security reasons. There were fears of the security issues, there were fears of internal disturbances. From the 2018 itself, we had seen different terrorist attacks, we had seen different you know internal security issues in Jammu and Kashmir, and it was not feasible then to conduct an election. But if we will look at the recent parliamentary elections which were held recently, we had seen a huge change in Jammu and Kashmir. It was noted that 58% of the population in Jammu and Kashmir went for the polling, and they went for the voting, and they showed that they had chosen democracy, peace, and goodwill over staying at home and revolting and all that stuff which they used to do. So right now, it shows the demand of the Kashmiri people. It shows the demand of the Jammu and Kashmir people, that what they want right now. They definitely want these elections should be happening. They had accepted what is their fate, and they want to mix with this constitution in a very well mannered. So with respect to that, the national political parties, regional political parties, they demanded elections to be held. And also we should know that when last year in December, when Supreme Court gave the judgment about the legality of the Article 370, in which they requested, and they advised the election commission to hold the elections in the Jammu and Kashmir by the 30th of September this year. And also, you know it was discussed about the restoration of statehood of the Jammu and Kashmir. So with these parties demand from the election commission of India that these elections should be held very soon. And with respect to that, the chief election commissioner of India, he said that, who is Raju Kumar, on Friday said the election commission of India was committed to hold elections at the earliest in the Jammu and Kashmir He also said that no internal or external forces will be allowed to derail the democratic processes, and he also noted that the result of voting in the Jammu and Kashmir during the parliamentary election, he noted that there was huge success in this, and he said that 58% of population in the parliamentary election participated, and the people chose democracy, peace, and goodwill. So he further said that the publication of final electorates will be conducted by August 20 and circulated among political parties. So, by the directions of Supreme Court, which were given in the December last year, now the Election Commission of India will definitely very soon declare the election dates for the Jammu and Kashmir. This was about it. Now here, what we can note from it here, some a preliminary question can be asked about the who which organization is responsible for the elections in the states. Is it State Election Commission or Election Commission of India? So such questions can be framed from this article, so we should know that it is the Election Commission of India. And please do join me during the evening session in which we discuss the daily quiz. We discuss the most important questions with respect to these articles, so that it will definitely help you revise these articles and also give you the idea how the questions could be framed from these current affairs. And also, my dear friends, if I was at your place, you know what I will do? I will definitely start noting down those questions on my notebook and prepare a question book before my next year's prelims, and help, and I will definitely revise them before my exams. One, it will help me in revising the current affairs, and second, it will definitely help me in solve in it would act as a mock test for me. So this would be the this is how this shows it how important it is for you to attend that daily quiz session. Now, moving to the article of today's discussion, it talks about the government says criminally are not applicable to scheduled castes and scheduled tribes. Recently we saw that Supreme Court gave its judgment. You know, by majority judgment 6-1, in which they said that it is this that states should go for subcategorization of STs, SCs, and they should go for that, so that this reservation could be diluted, could go down to those costs which had least impact of reservation on them till now. So with that judgment, the four judges further said that the government should look into the creamy layer concept in the scheduled castes and scheduled tribes also. So with respect to this money, scheduled caste, scheduled tribes MLAs were concerned with the respect to that judgment, and they were very much concerned, and they discussed it with the union cabinet and also the PM. And in with respect to this, the union cabinet on Friday categorically asserted that the principle of creamy layer does not apply to reservation for scheduled castes and scheduled tribes, that this principle of creamy layer does not apply to scheduled castes and scheduled tribes. What is this principle of creamy layer? That those who had got benefited from the reservation, they will be removed from this, and those who had not been benefited, they will be kept there. So if we look at the ethical way of watching at it, this seems very best policy. But right now, the government is not ready to introduce this creamy layer concept in the scheduled castes and scheduled tribes. And also, there was extensive discussion was held on the recent Supreme Court judgment that allowed states to subcategorize SCs and STs. The government is committed to the constitutional provisions given by the B.R. Ambedkar sir, where he said that reservation is the right of those people. In that, there is no provision of a creamy layer mentioned by the Dr. Bhimrao Ji Ambedkar sir with respect to the scheduled castes and scheduled tribes. So the government specifically mentioned that this reservation, this concept of creamy layer does not apply on scheduled castes and scheduled tribes. And also the PM assured that no creamy layer distinctions would be applicable within the quotas of jobs and seats in education institutions reserved for SCs and STs. And also they also mentioned that this the creamy layer principle was not part of the recent Supreme Court judgment. It was just assertion, it was just an मतलब कि एक ये था, मतलब कि kind of a request, we can say. uh, it was not kind of a recommendation, it was not a judgment, it is not something we have to follow, like we have to go for the subcategorization of scheduled courses. It is not something like that. It was just a recommendation. It is up to us whether we should go for this or not. But right now, the government is not in a mood to go for this kind of reservation, that is to go for the creamy layer concept of the reservation in SCs and STs. So this was about this article, very small article, important points which we should know in this. Now moving to the another article of today's discussion, it is about the India to roll out a new treatment regime for drug resistant tuberculosis. You know, India is getting to roll out BPAL, which is bedaquiline, pretamonoid, and linzoid regimen for all multi-drug resistant tuberculosis and extensively drug resistant tuberculosis patients. You know, these multi-drug resistant tuberculosis is one of the main concerns of the India right now, because the medicine we have does not you are not that much effect on that. So with respect to that, the India is going to roll out this BPAL, which is a bedaquiline, paratemonoid, and linezolid regimen for these multi-drug resistant tuberculosis and extensive drug resistant tuberculosis. This is a significant move in the country's battle against multi-drug resistant tuberculosis. You know, new drug regimen indicates good results. You know, this BPAL regimen, this new drug regimen indicating good results in countries such as Pakistan, South Africa, and Ukraine. You know, they had used this and it has shown very good results. It had shown how the costs for curing this TB has reduced to half, and how time period has reduced from 18 months to 6 months only. You know, with respect to this, the Soumya Swaminathan, the principal advisor of National Tuberculosis Elimination Program, said India is getting ready to roll out BPAL regimen for all multi-drug resistant tuberculosis patients. Also, with this BPAL regimen, we also need to scale up North NAT coverage. It will be essential element of the strategy. About this NORTH, it is the nucleic acid accommodation test, or NORTH, for TB. It is a molecular test used to detect the DNA of the Mycobacterium TB complex in a sputum of other respiratory samples. About the BPAL regime count, it cut short the TB treatment duration by half. So this is how it is important in controlling the TB, in eliminating the TB in our country. And we also know that we have this program to eliminate TB by 2030. We are working on that. You know, right now it seems very much difficult, but still we are working on that. Actually, we had this ambitious program to eliminate it by 2025, but the SDGs group, they World Health Organization, they had proposed to eliminate it by 2030, but we have this ambitious program to eliminate it by 2025. It seems very much impossible right now, but we are working on it. Even though we cannot eliminate it by 2025, but if we are able to eliminate it by 2030, it would be a huge success. So with respect to that, we have this national tuberculosis elimination program. You know, its principal advisor Swaminathan said India is getting ready to roll out a BPAL regimen for all multi-drug resistant tuberculosis patients. You know, this was about this. You know, questions could be asked from this BPAL regimen, how, and we should know these bedaquiline, the names of the drugs: bedaquiline, paratemonoid, and linzoid. You know, a question can directly be asked from these drugs, for which disease they are used, so we should know about these drugs. Now moving to the next article of today's discussion, it talks about the new population census. You know, it has been more than 3 years now that the decadal census has been delayed, and we know that despite there are several concerns having been raised about the consequence of not having a census. Right now, if we are not having the census right now, it will have huge consequences, because the world does change at a very fast speed. The population does change. The situations in the world, if we would see from 2011 itself, there were many such changes which would have impacted the population in a very severe way. For example, there was COVID. For example, there was, there was a recession was there. There are were many things which would have impacted the population. So it is very much important to have these elections, to have these census connected on a regular basis. Now it has been more than 3 years, and the government is saying because of the elections and because of the COVID, we could not conduct the census. We can understand that because of the COVID they could not conduct the census, but because of the elections, it seems that since because of the elections they did not conducted the census. It seems that census is not being being avoided more than it is being delayed. So with respect to it, it is very important right now to conduct the census. The census is, we should know that the census is not limited to offer a population count only. It includes a wide range of locational, familial, and individual information that serves to understand the changing population dynamics in its entirety. And also, the first and foremost limitation of avoiding a census lies in the reliability of all our large-scale surveys and periodic label force surveys carried out on a census frame that is 1.5 decades old. We can, it impacts the reliability of these surveys which we had conducted, and also the need to understand why we need to conduct this census, because there is need to understand many changes, transformation, not only in population count but also in other areas like education, the infrastructure and all that stuff which has changed from this decade, and also the impact of the COVID and recession on the people. So it is very important to conduct the population census, not only to count the population but also to count the impact of the various extreme things which happened in the last decade. And also, as we said, that it seems census is being avoided more than it is being delayed. Elections cannot be made an excuse to conduct a census. Also, it is very important to assess the government schemes on its population. We have to conduct the census. We should know what the population is, what are their requirements, and with respect to that we can form the schemes which can impact them in a proper way. If we will conduct the schemes on the basis of the 2011 census, then it will least impact the people. It will only impact very least number of people. Its impact would get diluted. So it is very essential to conduct the census right now. Government should go for it and solve this issue. There was someone getting mad outside. I don't know. Maybe they were beggars. Now let's move to another topic. So it is about the Banking Laws Amendment Bill 2024. You know, this bill has been introduced in the Lok Sabha, and this bill is proposing changes to banking laws, including an account holder. One of the changes they are bringing, that an account holder has the option of nominating up to 4 nominees. uh, it has been tabled in the Lok Sabha. With respect to this, the finance minister sources said bill aims to improve the governance standards. It gives the better protection for depositors and investors, and also improve audit quality in the public sector banks. And also the Ministry of State for Finance introduces the Banking Laws Amendment Bill 2024. It proposes to amend the RBI Act 1934. It proposes to amend RBI Act 1934, the Banking Regulation Act 1949, and the State Bank of India Act 1955. Also, the Banking Companies Acquisition and Transfer of Understandings Act 1970, and also the Banking Companies Acquisition and Transfer of Undertakings Act of 1980. So these are the acts which it is going to amend. So with this, it has been introduced in the Lok Sabha. Now let us see how the Lok Sabha treats it, and there are much more to be discussed with respect to this article. We will definitely see in the upcoming discussions of the daily news analysis. So in this article, the important thing which we need to know is an account holder It allows an account holder of having the option of nominating 4 nominees in his account. So with this we complete today's discussion. I hope you would like the video. I hope you would share it with your friends, and I hope you will definitely subscribe the channel, and please do write in the comments if any changes are needed here, and that any changes needed in the teaching style. So please do write in the comments. We'll definitely work on that, and we will definitely work hard to provide you the best information possible. With this we complete today's discussion. Thank you for staying with me. Thank you very much.